Ma'am, step back. You're not authorized here.
I am authorized. I have oral
You
arguments.
people don't
at
follow
9.
instructions. ID now.
I'm reaching slowly. You can verify me with judicial security.
You don't look like counsel. Step aside or I detain you.
It was 7:58 a.m. on the stone steps of the federal courthouse, the air still cool, the city just beginning to wake up. Ma'am, you need to step back. You are not authorized to be here. The woman stopped mid-step. She turned slowly, a leather briefcase hanging from her left hand. Her heels aligned perfectly on the marble. I am authorized to be here. I have court this morning. The officer shifted his weight hand resting near his belt. I asked you to step back. This area is restricted. You people need to follow instructions like everyone else. The words hung between them, sharp and unnecessary. The woman took a measured breath. I am entering the building to hear oral arguments. You can verify that with security. The officer shook his head. You do not look like counsel. ID now. Traffic hummed behind them. A bus hissed at the curb. The courthouse doors opened and closed as staff passed through metal detectors. The smell of fresh coffee drifted from a cart across the street. The woman reached into her bag, slowly, deliberately aware of every movement. Here is my identification. The officer barely glanced at the card before handing it back. This does not mean anything to me. You are loitering on federal property. Step aside or I will detain you. A clerk exiting the building slowed down. Two junior attorneys stopped near the railing. Someone across the plaza raised a phone. The lens pointed quietly in their direction. Sir, the woman said, her voice steady. You are making a mistake. I am a judge of this court. The officer let out a short laugh. Do not lie to me. Judges do not show up dressed like that. She looked down at herself. A gray blazer, simple slacks, no robe, no security detail, just another black woman in the wrong place in his mind. I am scheduled to hear United States versus Palmer at 9 o'clock. If you delay me, you are interfering with judicial proceedings. The officer stepped closer. You are interfering right now. Turn around and place your hands where I can see them. The crowd thickened by inches. Whispers rippled. Is this really happening? At a courthouse. Right here. The woman did not raise her voice. She did not step back. She stood still, eyes fixed on the officer, already understanding that logic had left the conversation minutes ago. You are detaining me without cause, she said quietly. Every second of this is being observed. The officer reached for his cuffs. The sound of metal echoed off stone. Time slowed. The courthouse loomed behind them, a building dedicated to law and order now bearing silent witness to something profoundly wrong, and no one yet knew just how wrong it was. The woman on the courthouse steps had not always walked with that quiet authority. Decades earlier, she had stood in very different lines, waiting outside overcrowded classrooms, waiting outside courtrooms where she was not yet allowed to speak, waiting outside offices where doors closed gently but firmly in her face. Her name was Judge Eleanor Brooks. Long before the marble steps and federal seal, she was a scholarship student at a public high school in Baltimore, the daughter of a postal worker and a hospital orderly. She learned early how institutions worked by watching who was welcomed inside and who was questioned at the door. She studied at night after double shifts at the campus library. She graduated at the top of her class, then law school, then clerkships where she carried boxes of briefs for judges who mispronounced her name but relied on her research. She became a federal prosecutor because she believed the law was supposed to protect people like her parents. She tried corruption cases, civil rights violations, police misconduct. She cross-examined officers who swore they had done nothing wrong while video told a different story. She built a reputation for precision, not emotion. She did not raise her voice in court. She let facts do the damage. Facts do the... When she was nominated to the U.S. Circuit Court of Appeals, the confirmation hearing lasted 3 days. Senators questioned her temperament, her impartiality, her ability to separate empathy from law. She answered every question calmly. She cited precedent. She cited statutes. She cited the Constitution from memory. She was confirmed by a narrow margin. The headline read, Historic Appointment. The subtext was clear. She would always be under scrutiny. She did not travel with security. She did not wear robes outside the courtroom. She arrived early. She carried her own briefcase. She believed the rule of law should look ordinary, accessible, unremarkable. She believed justice should not need an escort. The man who stopped her that morning had his own history, one far less examined. Officer Daniel Reeves had been with courthouse security for 9 years. He was hired young fresh from a regional police academy praised for vigilance and presence. His evaluations used words like proactive and assertive. They also included quieter notes. Difficulty with discretion. Escalates minor encounters. Needs improvement in judgment. There had been complaints. A public defender questioned why Reeves had demanded ID from her client but not others. A janitorial supervisor filed a report after being stopped twice in 1 week, while white contractors passed freely. Each complaint was logged, reviewed, closed without discipline. No body camera footage. No witnesses willing to escalate. Pattern without consequence. Reeves learned what worked. Confidence. Volume. Control. Question first, verify later. His supervisors wanted no incidents. To him, that meant stopping anything that felt out of place before it became a problem. He trusted instinct over protocol. Instinct had never cost him before. On that morning, his shift started at 7:30 a.m. He had been briefed about increased security due to a high-profile hearing. Remain alert. Challenge unfamiliar faces. Maintain perimeter integrity. The language was broad. The discretion was his. When he saw Judge Brooks approaching alone, no badge visible, no entourage, something clicked in his mind. She did not match his internal picture of authority. No suit jacket tailored sharply enough, no identification displayed, no recognition reflex from her face. To him, that absence was suspicious. What Reeves did not know was that Judge Brooks had authored opinions shaping federal law in 3 states. She had reversed wrongful convictions. She had denied qualified immunity to officers who violated constitutional rights. She had written a dissent cited by the Supreme Court. Her name was printed on the courthouse directory behind the glass doors he guarded. What Brooks saw in Reeves was familiar. The slight narrowing of the eyes. The premature certainty. The posture that signaled decision before evidence. She had seen it across witness stands and deposition tables. She had written about it in opinions footnoted with case law. As the seconds stretched on the steps, both carried their histories into the same space. One had spent a lifetime proving she belonged in rooms that were not built for her. The other had spent years being told his instincts were good enough. Around them, the courthouse continued its routine. Clerks checked watches, attorneys adjusted ties, security lines formed. No one intervened yet. Everyone assumed there must be a reason. Judge Brooks knew how these moments ended. Compliance, now correction later. Resistance, now escalation immediate. She chose her words carefully because she understood power. Not the power of authority, but the power of perception. Reeves felt something else. The pressure of eyes. The awareness that he had already spoken too loudly. That backing down would look like error. He told himself he was doing his job. He told himself credentials could be faked. He told himself that authority always looked different than this. Neither of them knew that within hours, this interaction would be dissected by attorneys, journalists, and judges. That training manuals would quote it. That careers would hinge on the next few minutes. At that moment, it was just a woman on courthouse steps and an officer convinced he was right. And the law was about to test them both. The officer did not lower his voice. He raised it. Step back now, hands visible. Judge Brooks shifted the briefcase to her other hand. She did not move her feet. I am entering a federal building where I preside. You can confirm my identity with the clerk's office or judicial security. Reeves shook his head. You are delaying security operations. That is not how this works. She reached into her bag again, slower this time, and produced a second card. It bore the seal of the federal judiciary. She held it out between 2 fingers. This is my judicial identification. Reeves glanced at it for less than a second. He did not read the name. He did not look at the seal. He waved it away. Anyone can make something like that. Step aside. Behind them, a young law clerk stopped completely. He recognized her face now. His eyes widened. He whispered something to the woman beside him. Phones came up higher. One person adjusted position to get a clearer angle. Another pressed record. Judge Brooks noticed the shift. She heard the change in ambient sound. The murmurs. The pause in foot traffic. She understood what an audience did to fragile authority. Officer, she said, you are refusing to verify credentials and escalating without cause. I am asking you one last time to call your supervisor. Reeves felt the moment slipping. He felt it in the silence that followed her words. He felt it in the weight of eyes on his back. To stop now would mean admitting error in front of strangers. To pause would mean doubt. He stepped closer. You are being disorderly on federal property. Disorderly for standing still, she replied. Disorderly for asserting my position. A man in a navy suit spoke up from the steps. That's Judge Brooks. I clerked for her last year. Reeves snapped his head toward him. Sir, stay out of this. Another voice followed. She's on the docket this morning. Reeves ignored them both. He reached for his radio, hesitated, then dropped his hand. He had already committed. Backing down now would look like loss of control. Ma'am, turn around. Judge Brooks did not resist. She did not raise her hands yet. She looked directly at him. Every person watching would later remember her expression. Calm, disappointed, certain. You are making a public mistake, she said. And you are being recorded. Reeves pulled out the cuffs. The sound cut through the plaza. Sharp, metallic, final. Gasps rippled outward. A woman near the railing covered her mouth. Someone said, "Oh my God." Someone else said, "This is insane." Reeves took Brooks by the arm. Not roughly, but firmly enough to signal command. He guided her away from the entrance toward the security office just inside the building. She walked without resistance. Her shoulders straight, her steps even. The cuffs closed around her wrists with a second click that echoed louder than the first. Inside the glass doors, the temperature dropped. The hum of scanners and footsteps replaced city noise. Security personnel froze mid-task, confused by what they were seeing. Judge Brooks spoke once more as they crossed the threshold. Please note the time. 8:05 a.m., Federal Courthouse entrance. Reeves did not answer. He did not see the clerk already dialing a number. He did not hear the security supervisor whispering urgently into a headset. He did not notice the courthouse administrator rushing toward them from the far hall. He was focused on procedure, on finishing what he had started. Judge Brooks was already planning something else. Not retaliation, not anger, documentation, sequence, law. Behind them, phones continued to record. Outside, the crowd pressed closer to the doors. The courthouse seal gleamed above an entrance where justice had just been delayed by prejudice, and everyone watching understood that whatever happened next would not stay contained within those walls. The cuffs tightened with a quiet, mechanical certainty, metal settling against bone. Judge Brooks felt the pressure immediately, not sharp, but deliberate, a reminder of control. Each step inside the courthouse echoed louder than it should have, the sound of her heels muffled by marble and carpet, the sound of authority stripping itself from the room. Reeves guided her down a side corridor reserved for security incidents. The hallway smelled faintly of disinfectant and old paper. Fluorescent lights hummed overhead. A maintenance cart stood abandoned near a doorway, its yellow sign warning of a wet floor. No one was watching. They passed framed photographs of past judges lining the walls, black and white portraits, robes, stern faces, men almost entirely. Judge Brooks noticed them in her peripheral vision, felt the irony settle deep in her chest. Her own portrait hung 3 floors above them. Inside the security office, the door closed with a soft thud that felt heavier than it sounded. The room was small, windowless. A desk bolted to the floor, 2 chairs, a camera in the corner blinking red. The air was stale, unmoving. Reeves instructed her to sit. She complied. The chair was cold plastic molded without comfort. Her briefcase was placed on the floor just out of reach. Her wrists rested on her lap, the cuffs glinting under fluorescent light. For the first time, silence filled the space. Reeves stood near the door, arms crossed. He avoided her eyes now. His jaw worked slightly, as if chewing something bitter. He pulled out a notepad, then hesitated, unsure what to write. Judge Brooks closed her eyes briefly, not in fear, but in calculation. Time? Location? Witnesses? Failure to verify credentials? Unlawful detention on federal property. She assembled the outline automatically, the way she had done for years before issuing opinions. She thought of the hearing scheduled for 9, of the attorneys already seated shuffling papers wondering where she was, of clerks refreshing calendars. Delay would ripple outward. Everything did. Outside the office, footsteps hurried past, voices overlapped. Someone knocked once softly, then more firmly. Reeves did not answer. "You can still fix this," she said quietly. "Call your supervisor. Verify my identity. End this now." Reeves swallowed. His confidence had thinned, but pride still held. He glanced at the camera, then back at her. "We will sort it out," he said. "Sit tight." Sit. Sit tight. The phrase landed wrong in a room built to restrain. Minutes stretched. The hum of lights grew louder. Judge Brooks felt the cuffs dig slightly as her hands shifted. She did not complain. She noted it. In the hallway, raised voices. A security supervisor arguing. A clerk insisting. The words judge and circuit carried clearly through the thin walls. Reeves stiffened. The door opened abruptly. A senior security official stepped inside, eyes flicking immediately to the cuffs. His face drained of color. "What is going on here?" he asked. Reeves spoke quickly, defensively. "Suspicious individual. Refused to comply, claimed to be a judge." The official looked at Brooks, then at her wrists, then back at Reeves. His voice lowered. "Do you know who this is?" Judge Brooks met his gaze. "Yes," she said, "you do." The man exhaled slowly, already reaching for his radio. "We have a problem," he said. "A serious one." For the first time since the confrontation began, Reeves felt the ground shift beneath him. The room seemed smaller. The camera blinked, steadily indifferent. Judge Brooks sat very still. She knew the worst part was over, and the consequences were just beginning. The confirmation came quietly, without ceremony. The security supervisor stepped back into the room with a phone still pressed to his ear. His posture had changed. Shoulders squared, voice lowered. The kind of posture reserved for people who suddenly understood the stakes. "Yes, sir. She is here now. Yes, handcuffed. Understood." He ended the call and turned toward Reeves. "Remove the cuffs. Now." Reeves hesitated for half a second, long enough to register fear. Then he knelt and unlocked them. The metal released with a muted click. Judge Brooks flexed her wrists slowly. Deep red impressions marked her skin, already swelling. "I apologize for the delay," the supervisor said, though his eyes never left Reeves. "This should not have happened." Judge Brooks stood. She adjusted her blazer, smoothed the fabric as if restoring order to something larger than clothing. She did not rub her wrists. She did not speak yet. Another man entered the room moments later. Gray hair, dark suit, federal judicial security badge clipped neatly at his waist. The chief marshal. He took one look at her face and then at Reeves. His expression hardened. "Judge Brooks," he said, nodding slightly. "I am deeply sorry." She inclined her head once. "Thank you. Please note the time. 8:21 a.m. The chief marshal turned to Reeves. "Officer, you were instructed to verify credentials. Why was that not done?" Reeves opened his mouth, closed it. "I believed the credentials were fraudulent." "On what basis?" She did not match expected appearance. The room went silent. The chief marshal let the words sit. Then he spoke carefully. "Expected appearance of whom?" Reeves did not answer. A clerk rushed in, breathless. "The courtroom is waiting. Counsel is asking for guidance." Judge Brooks picked up her briefcase. She held it firmly now. "I will proceed to the bench. This matter will be addressed afterward." As she walked out, staff moved aside instinctively. Heads lowered. The hallway felt different now. Quieter. Heavier. Reeves remained where he stood. No one looked at him. An hour later, the security footage had been preserved. Statements were being typed. Phones were ringing in offices that rarely heard bad news before noon. By midday, the chief judge had been briefed. By early afternoon, the administrative office of the courts requested a full report. By evening, an internal investigation was formally opened. Reeves was placed on administrative leave before his shift ended. Judge Brooks finished the hearing without mentioning the morning. Her questions were precise. Her rulings measured. No one in the courtroom could tell what had happened outside, except by the faint marks still visible at her cuffs when she adjusted her papers. But the revelation had already occurred, not just of who she was, but of how easily the law could be violated at the very door sworn to protect it. The response did not stay internal for long. By the next morning, a 30-second clip from a bystander's phone appeared online. No commentary, no captions, just a uniformed officer blocking a black woman at a courthouse entrance. Voices raised, authority asserted, and then the unmistakable sound of handcuffs closing. Within hours, it was everywhere. Legal blogs dissected it first, then mainstream media, then social platforms where outrage traveled faster than context ever could. A U.S. Circuit Court judge detained at her own courthouse became a headline that did not need explanation. By noon, the video had crossed 1 million views. By evening, it had tripled. Comment sections filled with disbelief, anger, and recognition. Attorneys shared it with captions about constitutional violations. Former clerks shared it with quiet fury. Ordinary viewers shared it with one sentence repeated over and over. This could have been anyone. Judge Brooks did not give interviews. She did not issue statements. She instructed counsel instead. The complaint was filed within 48 hours. It was precise. Unlawful detention. Failure to verify credentials. Violation of Fourth Amendment rights. Equal protection violations. Supervisory negligence. Each allegation supported by timestamps, witness statements, and security footage already preserved. The courthouse administration launched its own review. Federal Judicial Security issued a memorandum revising procedures, mandatory credential verification, de-escalation requirements, immediate supervisor notification for any detention involving court personnel. Training updates were scheduled within the week. Officer Reeves was interviewed twice. The first time he claimed confusion. The second time he cited instinct. Neither explanation survived the footage. Neither survived the witnesses. Neither survived his prior complaints now reopened and re-examined under scrutiny that had never existed before. 3 weeks later, the findings were released. Reeves had violated protocol. He had failed to verify credentials. He had escalated without cause. He had detained a federal judge based on appearance rather than evidence. His actions were deemed unreasonable and discriminatory. He was terminated the same day. The settlement followed quietly. No admission of wrongdoing, a figure large enough to be symbolic. Judge Brooks directed the funds to judicial education programs and civil rights training initiatives. She did not keep a dollar. What remained was precedent, not legal precedent, cultural precedent. Training academies added the footage to coursework. Law schools discussed it in constitutional law seminars. Judges referenced it privately when talking about access perception and the fragility of authority. Officer Reeves did not speak publicly. His career in courthouse security ended without ceremony. Applications to other agencies went unanswered. Judge Brooks returned to her routine. Early mornings, heavy dockets, careful opinions. But something had shifted. The courthouse steps where it happened felt different now. Staff paused longer. Officers verified more carefully. The assumption that authority had a single look had been challenged where it mattered most. Justice had not been loud. It had been methodical. And it had left a mark. What happened on those courthouse steps was not complicated from a legal standpoint. It only felt complicated because authority was involved. Under the Fourth Amendment, a detention requires reasonable suspicion based on specific articulable facts. Not a feeling. Not a guess. Not an impression. Officer Reeves had none. Judge Brooks was walking into a public federal building during business hours carrying a briefcase following routine procedure. There was no criminal behavior to point to, no threat articulated, no lawful basis to stop her. The moment credentials were presented, the obligation was even clearer. Federal protocol requires verification, not dismissal. Refusing to verify and escalating instead transforms a stop into an unlawful detention. Adding handcuffs completes the violation. The law is explicit on this. Authority does not excuse error. It amplifies responsibility. But the legal failure was only one layer. The deeper issue was bias. Not shouted, not confessed, but quietly decisive. The assumption that authority must look a certain way. That power wears a uniform, carries a badge, or arrives with an escort. When those expectations are not met, doubt creeps in. Doubt becomes suspicion. Suspicion becomes action. This is how bias operates most effectively, not through hatred but through certainty without evidence. Judge Brooks understood this long before it happened to her. She had written opinions about it. She had ruled on cases where officers claimed instinct and courts demanded facts. This time, she was not behind the bench. She was standing on stone steps subject to the same assumptions as millions of others. That is why this incident mattered. If a U.S. Circuit Court judge could be detained at her own courthouse, credentials ignored, authority questioned, then position alone is not protection. Knowledge alone is not armor. Compliance does not guarantee safety. What protects people is procedure, accountability, and witnesses willing to record. For viewers, the lesson is practical. If you are stopped, stay calm. Speak clearly. Ask for the legal basis. Present identification once. Do not argue endlessly. Request a supervisor. If you can safely record, record. If others are present, ask them to witness. Time and documentation matter. And understand this. Being calm does not make a stop lawful. Being respectful does not cure a violation. The law is not based on demeanor, it is based on standards. Judge Brooks never raised her voice. She never resisted. She followed instructions even when they were wrong. Justice came later not because she demanded special treatment, but because the system was forced to look at itself. That is the final truth of this story. Justice does not arrive because someone is important. It arrives when rules are followed, violations are exposed, and consequences are unavoidable. The courthouse still stands. The steps are still there. People walk them every morning. The difference now is that more eyes are open.